Good morning, everyone. It's time for us to take a little break from criminal process and take a little detour into the other side of the courts, which is the civil side, civil litigation. This week's topics are not really related to what we've been doing before or what we'll be doing next week, or what you're doing this week on your final project. It is a separate topic. So think of it as being separate. Don't try too hard to relate it to what we've done before or what we are going to do after or what you're writing about on the final project, because civil litigation is an entirely different legal pursuit. It has different theoretical bases, it has different procedures, different courts sometimes, and certainly a different goal. And we'll get into that in a minute, but first, before I start talking about the process of civil litigation and what we're going to be discussing this week, I want to remind you that even though this is week 7, not the last week of class, but the next to last week, this is the week when your final project is due. It's due on Sunday the 29th at midnight, or 11:59 p.m. To be precise. And it's going to require that you do a couple of things. Not that you write an entirely new paper, because the whole process of reaching this final project goal is that you wrote a milestone 1 paper, and you got criticized on that, and I made suggestions as to how you could improve it. And some of you wrote it more than one time. You wrote a milestone 2 paper, the same thing happened, and now you're about to put those 2 milestones together into your final project. But, here's the caution. The final project is not just cobbling together milestone 1 and milestone 2, putting them into one paper and submitting them. Be sure before you write your final project that you look very carefully at the final project grading rubric. It is a long list of topics that must be covered in that final project in order for your grade to be a good one. And I know all of you would like to have a good grade on that, and all of you really deserve it. You have good minds, you think well, and you write well. Don't blow this opportunity to do well on the final project, because you've already done the groundwork. The groundwork is contained in those milestones that you've already written, but the milestones are not the whole thing. So be sure to go over all of the rubric. Ask me any questions you have as you're writing your final project. Send me an email. I am very, very happy to help you with it, but once you've written it and submitted it, I can only do so much. So try to ask me before you submit your final project if you have any questions about what you're supposed to do. Now, let's set that aside for a minute and jump to this week's topic, which is civil litigation. Now, up to this point, we've been talking about criminal cases. And in criminal cases, the parties are the state, and by state I'm using that in a very generic term to mean the government or the people. The state is the party that brings a criminal case against a person who has supposedly violated some of our criminal laws and caused damage to society as a whole. That's the theory. Now, there's always a victim, or usually a victim of a crime, but the victim of a crime, as you may have discerned in your studies so far, the victim of a crime bears practically no relation to a criminal prosecution. The criminal prosecution doesn't have anything to do with the victim except as a witness. It's not meant to compensate the victim. It's not meant to wreak vengeance for the victim. It has nothing to do really with the victim. The victim is kind of a byproduct of a crime. A criminal prosecution has a goal, and that goal is to determine the guilt or innocence of the person accused of having committed the crime, and if that person is found guilty, to punish him or her. Punishment is the goal of a criminal prosecution. Now, Here we are in civil litigation, and we've got all this punishment mindset. Get it out of your head. Because in criminal litigation, punishment is not the goal at all. The parties to a criminal, I'm doing it too. The parties to a civil suit are a plaintiff. These are two non-state parties, two private individuals, or more than two, but we're going to simplify it here, just say two. There's going to be a plaintiff, the person who has been damaged, or injured, and that can be an actual physical injury, physical damage that you can see, or it can be mental anguish, it can be the loss of income, it can be many, many kinds of loss, but we're going to lump them all under the term damage. So the plaintiff is the person who's been damaged, and the defendant is the person that the plaintiff thinks has caused that damage. So our two main parties are, plaintiff and defendant. Confusingly, we use the same word, defendant, in both civil and criminal litigation. Please don't let that throw you. The law has a nasty habit of assigning more than one meaning to several words. So here we're not talking about a defendant in the criminal sense, not someone who's broken a criminal law and needs to be punished. Here we're talking about a person that the plaintiff thinks is the one who has caused him or her damage. So those are our two parties. Now, what is the goal of civil litigation? It's not punishment. It's compensation. The plaintiff has suffered a loss. He or she thinks that the defendant has caused that loss. And so the plaintiff sues the defendant, brings the defendant into court, to ask the court to do two things. One, assign a value, a dollar value, to what the plaintiff has lost or the damage the plaintiff has suffered. And two, to hold the defendant liable or responsible for compensating the plaintiff for that loss. Now, as I said in my written announcement, the law isn't magic. I mean, we can't wave a wand and suddenly put the plaintiff back in the position that he or she occupied before the loss was suffered. You can't turn back time. The best the law can do is to try to assign a dollar. Excuse me, I'm so sorry. My oak pollen allergies are still acting up. Assign a dollar value to what the plaintiff has lost and make the person responsible for that loss pay that dollar value to the plaintiff, to try to make the plaintiff as whole again as possible. Now, clearly, again, we're not talking about magic. We're not talking about time travel. We're talking about the limited power that human beings and the law have to try to compensate a person for damage that person has suffered. Let me give you an example. Let's say that you're traveling in your car on a highway, driving, minding your own business, driving along, obeying all the laws. You've got your seatbelt buckled. You're not talking on a phone or texting. You're obeying the speed limit. And all of a sudden, out of the blue, with no fault of your own, and fault is a big factor in civil litigation, through no fault of your own, here comes another car speeding by and it smashes into your car. It does you some damage to your body. You've got whiplash, you've got a broken arm, you've got a dislocated knee, let's say. We're making this bad. But it does a lot of damage to your car. Your car is totaled. So when the dust settles and you've been to the doctor and your car's been towed away and evaluated and so forth, you discover that the monetary value of your loss of income because you've missed work because of your injuries and you don't have a car to drive, your medical bills, the cost of replacing your car, all of that has totaled, let's say, $100,000, just a nice round figure. So you and your insurance company, we won't get into that, but your insurance company will be very heavily involved in this. You decide to sue the person who drove that car so recklessly and ran into you. Okay, so you sue that person. You are the plaintiff. Your name is Jane Doe, and the defendant's name is John Roe. So you sue John Roe in a civil court, and we won't talk about venue or jurisdiction here. That's too complicated. But let's just say we found the right court, and we're doing it in the right place. So Jane Doe sues John Roe for $100,000. What happens in that lawsuit? Well, before we get to court, Jane has to find out as much as she can about John, about his insurance coverage, about what exactly happened, has to read the police report, has to find out what kind of insurance coverage John has to find out what kind of income John has, what ability to pay, and so forth, because that's going to be relevant in the end, although it is not relevant to liability or responsibility. Then that's a process of discovery, and that's what we're talking about this week in our topic, the process of civil discovery. It might be done through interrogatories, that is to say, written questions that are sent to John and his attorney that he must answer under oath. It might be done in a deposition, a face-to-face questioning, also under oath, but not in front of a court, in front of a court reporter or other notary public, someone who is authorized to administer an oath. It might be done through requests for documents, such as John's own medical bills. John also, as a defendant, has a right to discover as much as he can about Jane. What medical bills has she actually incurred? What was the actual value of her car? What fault might she have contributed to this accident? All kinds of things are learned through the process of discovery. When that process is complete, and it takes a long time, if the parties can't reach a settlement on their own, then they go to trial. And the trial is, this is contrary to some of the written readings that you have this week, but let me just tell you that most civil litigation, most civil trials are in fact jury trials. You're going to read some things that tell you that they are not. That's not true. They're almost all, if a civil case gets to trial, and most of them don't, it's usually in front of a jury. And by the way, more than 90% of civil suits that are filed are settled before they ever get to trial. Very few are actually tried. Anyway, the ones that are tried, the goal of the trial, the goal of the court and the jury is to do two things. One, to determine whether the plaintiff has made a good case proving that the defendant is liable. And it's the plaintiff's burden to do that. And two, if the defendant is found liable, how much is this case worth? So the jury, with the help of the judge usually, is tasked with the job of putting a dollar value on what the plaintiff has lost and rendering a judgment, either finding the defendant not liable, or if the defendant is found liable, telling the defendant how much he or she has to pay. In our case, he, because it's John Roe, has to pay our plaintiff, Jane Doe, for her loss. That's a civil suit in a very small and not very detailed, because this is just one course and not the entire, first year of law school. This is the goal of a civil suit. Now, your discussion board this week asks that you. I look very worried here. I'm not really. Your discussion board this week asks that you talk about the process of civil discovery. How extensive should it be in order to balance the interests of justice and judicial efficiency? A long, drawn-out, wide-ranging discovery process, which sometimes is necessary in very complicated civil suits, sometimes is seen as a reduction, as a way to reduce judicial efficiency. Your opinion matters here, and in the discussion board, you get to say what your opinion is. Now, I better be quiet. We're 14 and a half minutes in this video. That's incredible. That's twice as long as I usually like to talk, and twice as long as you probably like to listen. So I'm going to be quiet. Read the material, weigh in on the discussion boards, and as you're working on your final project, which is totally unrelated to this topic, let me know if you have any questions. Have a great week.